Well, good afternoon to all who have joined in Melbourne and across Australia, and good morning to others around the world, including attendees from France, the origin of the Green Rights Coalition. I would like to start by acknowledging that I am here at the University of Melbourne, which is built on the land of the Wurundjeri peoples of the Kulin Nations, who remain its traditional custodians. And I would like to pay my respects to elders past, present, and emerging. This recognition is especially fitting for our exploration in today's webinar of the legal and social context of attitudes to the earth, or country as it is considered here. My name is Margaret Young, and I'm a professor here at Melbourne Law School and director of our Institute for International Law and the Humanities. I'm very excited to be marking Earth Day 2024 along with my distinguished Melbourne Law School colleagues, Professor Jackie Peel, Dr. Erin O'Donnell, and Mr. Dylan Asafo, in what is the first of a series of 6 webinars around the globe, available in French, English, Portuguese, Spanish, and Chinese, which ask, why do we need green rights? In today's webinar, we will consider ways that we may relate to the environment through law, drawing on green rights and international environmental law, notions of legal personhood and rights in our region, including in the Pacific Islands. But let me first place our discussion in the context of human rights law and current international legal developments. Many participants in today's webinar will be aware of the general background of rights protections, including in international, regional, and domestic legal instruments. These protections are sometimes separated into first, second, and third generation rights. The so-called first generation rights, protected in the International Covenant on Civil and Political Rights and in charters of several Australian states and territories, including Victoria's, will protect basic civil and political rights. As we know from the Human Rights Committee's decision in the Billy case, many of these rights link with environmental issues. In that case, Australia's failure to adequately protect Indigenous Torres Strait Islanders against adverse impacts of climate change violated their rights to enjoy their culture and be free from arbitrary interferences with their private life, family, and home. The so-called second generation rights protected in the International Covenant on Economic, Social and Cultural Rights, which, like the ICCPR, entered into force in 1976, link with environmental issues, given their material focus on the protection of health and adequate standard of living. A third generation of human rights, or environmental rights, more expressly brings the environment to the fore. Green rights might recognise the human right to a clean, healthy and sustainable environment, as the United Nations General Assembly did in 2022, which Professor Peel will discuss. This is the formulation that is currently being considered by the Australian Parliamentary Joint Committee on Human Rights in its inquiry into Australia's human rights framework. The Australian Human Rights Commission's recent position paper has included a draft provision on the right to a healthy environment. This is in addition to proposed federal protections for civil, political, and economic, social, and cultural rights. The Commission's proposal provides that every person has the right to an environment that does not produce adverse health consequences. This means that a person has the right not to be subject to unlawful pollution of air, water, and soil, to access safe and uncontaminated water, and so on. There's to be no unjustified retrogressive measures with regard to this right. Such an idea has been developing internationally for some time. In 2012, the Human Rights Council established the mandate for a special rapporteur on human rights and the environment. In 2017, a global pact for the environment was presented to the United Nations after some discussion, and this helped feed into what ultimately became the General Assembly resolution of 2022. I've written about how a more binding form of green rights could bring balance to an international legal system that has many hard law protections for economic activities, such as in trade and investment law, but relatively soft law protections for the social and environmental systems upon which those economic activities actually depend. From the perspective of the fragmentation of international law, I'm in favour of broader systemic legal recognition for the environment. Of course, third-generation rights do not have to take the form of a right to a healthy environment. They could recognise rights of animals or all living beings, of rivers, mountains, or ocean spaces, as will be discussed by Dr. O'Donnell. Legal personhood is a notion constructed by legal systems and has been used in what might seem to be novel and strange ways, such as legal personhood for corporations. As an international lawyer, the legal personalities of states might seem natural to me, but there is a backstory and a future one. It is also important to note the downside of rights. For example, they may risk directing attention away from obligations and also reinforce boundaries and relations that fail to adequately support the interdependence of all life. They may prioritise values that are more readily visible in liberalism and leave others hidden. A critical perspective is therefore to be encouraged, alongside the hope and inspiration that comes from the prospect of greater environmental protection. The Pacific Islands, for example, have used the very best of legal advocacy, but with a constant awareness of broader historical and social context, as will be described by Dylan Asafo today. I'm very excited to share today's event with a wonderful set of speakers who have thought deeply about green rights. They'll each present for between 5 and 15 minutes, after which we will have a brief Q&A via the written chat before we close at 5 p.m. Before I introduce our speakers in turn, I would like to play a short video prepared by our colleagues at the Green Rights Coalition who have spearheaded today's event.
Have you ever heard of the Green Rights Coalition? We're a global movement uniting people to champion a new generation of fundamental rights linked to environmental protection, our green rights.
Our planet has been on fire for too long. The time has come to unite and stand up for our right to a healthy environment.
Because after 50 years of declaration and treaties, efforts to protect the environment and life on Earth are clearly insufficient.
Because on a daily basis, we witness the collapse of biodiversity and put life on Earth at risk. Because climate change threatens our way of life.
Because air, soil, or water pollution doesn't stop at country borders. Because beyond our difference and our origins, all living beings form the community of life on Earth.
Because we need to ensure our planet's ability to produce renewable resources for generations to come.
Because technology and technical rules alone cannot solve the environmental crisis. Because we need values, we need principles, we need to rebuild our society on new foundations.
We need to make a pact with nature, a pact that binds us all together as inhabitants of this planet. We need a new pact to recognize our green rights and duties.
A pact that can become the foundation of a new social contract for humanity. A contract that allows us to protect the environment because it's the best way to bring people the possibilities of a better life.
A pact that recognizes the right of everybody to a healthy environment, that recognizes the duty of states and citizens everywhere to take care of the environment.
A guiding compass that will enable access to information, justice, and process for citizens of the Americas and the world.
A pact that answers to young generation, civil society, all of us, actually, because we need to lay the foundation for a new and more united world to better protect our planet and mankind.
The Green Rights Coalition champions this new social contract. We advocate the recognition of green rights at the national, regional, and international levels to ensure the fulfillment of other human rights and to protect the planet.
The United Nations is ready to act. The General Assembly has adopted a pivotal resolution recognizing the right to a healthy, clean, and sustainable environment.
This is a first step, but we need to go further. We call on states to recognize environmental rights and duties in a legally binding treaty.
We need to recognize our green rights in every continent, in Africa, the Americas, Asia, Europe, and Oceania.
At the national level, we also push for the recognition of green rights in states' constitutions.
A secure climate, clean air, safe water, sustainable food are not merely privileges. They are fundamental rights that must be observed and respected by everyone.
Because there is only one planet, we have no choice. Today, time has come to wake up and stand up for your green rights.
Our planet, our rights.
Our planet, our rights.
Our planet,
our planet, our rights.
Our planet, our rights.
Our planet, our rights.
Our planet, our rights.
Well, wonderful to see so many people from around the world supporting green rights, including some of my academic colleagues who were in the International Legal Expert Group for the Global Pact for the Environment drafting process. I'd like to now hand over to Professor Jacqueline Peel, who will address the question of green rights and international environmental law. Jackie is Director of Melbourne Climate Futures, the university's multidisciplinary climate change initiative, and she has co-authored several field-defining works, including the text Principles of International Environmental Law and the Oxford Handbook of International Environmental Law. She served as a lead author in Working Group 3 of the Intergovernmental Panel on Climate Change for its 6th assessment report and has been leading the charting of climate change litigation for many years. Over to you, Jackie.
Thanks very much, Margaret. And I've got a few short slides, so I'm going to share those now. Hopefully that's appearing on the screens where you are as well. So thank you very much for that introduction, Margaret, and also too for the inspiring video that was shared from the Green Rights Coalition. I think it's a very appropriate call to action, not just for Earth Day, which is one point at which we might remember this particularly, this imperative to safeguard the planet. But as we face very significant crises globally, including one that I work on quite a lot of climate change, the need to continue to explore avenues in all directions to try and improve our relationship to Mother Earth. I'm going to just provide a few brief framing comments around green rights and their intersections with international environmental law, and I'm looking forward to hearing my colleagues' contributions, Dr. Erin O'Donnell's more on some of the aspects around nature rights and also the very important perspectives that Dylan's going to share around how rights are conceived and their limitations potentially in the Pacific. But the first point to start with in the international environmental law context, which was hinted at in the video that you just saw, is that green rights are a long-standing feature of international environmental law. In fact, we might say that they were present at the birth of international environmental law. The Stockholm Conference in 1972, which was the first occasion really that the international community came together to voice concerns about protection of the environment, also featured very prominently as the first principle of the Stockholm Declaration, this idea of fundamental rights to freedom, equality and adequate conditions of life in an environment that permits a life of dignity and well-being. And I also like to highlight the second part of this provision from the Stockholm Declaration that talks about the solemn responsibility to protect and improve the environment for present and future generations. If I have a criticism of green rights, it's that sometimes there's more emphasis on the rights elements than on the duties and responsibilities that should go along with those. The Rio Declaration in 1992 affirmed similar ideas around the importance of a rights framing at the centre of concerns for sustainable development, in the sense of affirming that human beings are entitled to a healthy and productive life in harmony with nature. So these foundational documents in international environmental law do recognise green rights. They are soft law documents, so they're not legally binding. So they're more aspirational in terms of expressing the kinds of ideas that states at these different points in time were expressing as a key foundational principle of international environmental law. What we've seen in more recent times is green rights gaining much more momentum. And that's been a consequence really of the greater interlinkages that we're seeing between environmental degradation and impacts on human rights. So as we've seen more and more how air pollution, water pollution, biodiversity loss and climate change more generally impacts human communities, we're beginning to see in real time the links that exist between environmental protection and realisation of human rights. And climate change is really the poster child here. It obviously has very broad-ranging impacts on human health and well-being, as well as on our environment. And so climate change is serving as a lens to bring together or weave together even more closely human rights and environmental issues in this language around green rights. Margaret hinted at the fact, didn't just hint, she talked quite eloquently about the fact that human rights have evolved in international law under the auspices of international human rights law. And it's important to recognise that these areas of law in the international system have generally sat in separate silos, international environmental law on one side and international human rights on the other. But what we're seeing with this increasing interlinkage and the evolution of green rights is those areas of law coming closer together around common concepts of needing to safeguard the environment to ensure human health and well-being. A good example of that kind of interlinkage we find in the Paris Agreement, which is now the main climate treaty that we have internationally. It provides in its preamble, so not a binding provision, but an aspirational provision, that states acknowledge that climate change is a common concern of humankind and that parties should, when they're taking action to address climate change, respect, promote and consider their respective obligations on human rights. So creating a very direct linkage between international environmental law and human rights. You'll notice in what I'm saying there that the framing of green rights that I'm using is one based on human rights. That's not the only possible framing that we might take of green rights. We could think about green rights in terms of nature's rights, for example. But in international environmental law, certainly the understanding of green rights that's emerged is one that's been based on human rights and the different kinds of human rights that might pertain to environmental protection. In general, we can divide that between two areas: procedural rights and substantive rights. So procedural rights you might think of as the sort of first step towards realising a clean and green future. They're about rights to access information, to participate in decision making and access to justice. The United Nations Environment Programme in recent reports talks about these kinds of rights as part of an environmental rule of law. And they are reasonably long-standing in international environmental law, with origins in the Rio Declaration and several regional conventions in Europe and in Latin America expressing these procedural environmental rights. But the Holy Grail for many has been the substantive rights to environmental protection or green rights in the kinds of terms that were talked about in the video. Rights to clean air, a safe and stable climate, access to safe water, healthy and sustainably produced food, non-toxic environments in which to live, work, study and play, and healthy biodiversity and ecosystems to support that. Those kinds of ideas have had a long history again of debate and discussion, but recently gaining more momentum that's really led up to the United Nations General Assembly resolution at the end of 2022 that was mentioned again in the video on the right to a healthy environment. I'm paraphrasing there, but it's essentially the idea that there is a substantive obligation on states to ensure that kind of right. At the moment, obviously, United Nations General Assembly resolution is not a binding treaty of the kind that would generate obligations on states in the same way as a treaty like the Paris Agreement. So many see that there is still further steps to go in terms of what are going to be the next steps to give effect to this right. We've achieved recognition. What comes next? Some of the next steps were highlighted in the video. They might be adopting the rights as part of an international treaty, as part of a regional convention, or in national laws, as Margaret was alluding to with the discussion of that in the Australian context. In my final slide, I just wanted to point to one other context in which this debate and discussion around green rights is occurring, and which may offer some ways of understanding both the scope and ways that green rights may be enforced in international law. And that's through the mechanism of litigation, where we're starting to see, particularly this year, instances of international climate litigation. Excuse me. So we've got 4 cases that are on foot in different international courts and tribunals that concern versions of green rights applicability and offer some sense of how these rights might be given effect. If you've been watching some of the news, probably the most recent instance of this was the European Court of Human Rights ruling in the so-called Swiss grandmother's case involving a group of older women in Switzerland, arguing that the Swiss government's measures to address climate change were insufficient, with impacts for their health and well-being over the longer term, and that claim was upheld in the European Court of Human Rights. It's obviously not green rights in the sense of a substantive right to a clean, healthy, sustainable environment, but it's using the kinds of first-generation rights protections like civil and political rights to achieve environmental ends in the same kind of way. We are expecting later this year the hearings to occur before the International Court of Justice in its current advisory opinion request, brought at or spearheaded by Pacific Island states, particularly Vanuatu, to clarify the extent of states' obligations in respect of climate change and the legal consequences of failing to fulfil those obligations. There are several obligations that are being examined by the court in this advisory opinion ruling, but one set of obligations relates to human rights and the extent to which they require a safeguarding of the climate system and environment for the benefit of present and future generations. I'll conclude there just by saying that green rights are not new as such, but they are gaining increasing momentum, and new avenues are beginning to appear both through the sort of legislative arm of international environmental law and through the judicial arm of disputes that are coming before courts to help us begin to understand the scope of these rights and how they might be better enforced in international law. I'll stop there and stop my sharing and hand over to Erin, who's doing the next presentation.
Well, thank you very much, Jackie, and I agree with you that adjudication is a really important sphere for the articulation of green rights as they may be developing in customary law as well as through treaties. I think the advisory opinion on climate obligations is going to be momentous for the International Court of Justice, particularly given the large number of participants in that process, not just states, but international organizations. And I think there's a scope to really not develop, but articulate what has been developing in international law with respect to due diligence obligations and with respect to notions of rights protections. So thank you very much for all of those very rich perspectives. Our second speaker, Dr. Erin O'Donnell, will now address relational and legal personhood in environmental law. Erin is Senior Lecturer, Deputy Director of the Melbourne Centre for Law and the Environment, and ARC, Australian Research Council, Research Fellow. She is the author of Legal Rights for Rivers, Competition, Collaboration and Water Governance, and her current research explores the opportunity to increase traditional owner power and resources in water and create more sustainable and legitimate settler state water laws. Over to you, Erin.
Thank you so much, Margaret. Greta, are you able to share my slides or would you like me to have a go? Ah, perfect. Just wait for that one to pop up. Beautiful. All right. So thank you very much for having me here today, everyone. I'll begin with an acknowledgement of country. I'm speaking today on the lands of the Gadibanud people. So I'm actually down along the Victorian coast. This is part of the Eastern Maar people's country. I pay my respects to their elders past and present, and I acknowledge that they've never ceded their rights to care for their lands and waters. And this is a really important contextualisation, as Margaret acknowledged in the beginning as well. In having this conversation in Australia, we are doing so in the absence of any kind of treaty between Indigenous peoples and the settler state. So their rights remain, they are unceded, they persist to this day. So if we move on to the next slide. What I'm going to be talking about today is this concept of what is broken and perhaps what we can do to repair it. But before I begin there, I also want to acknowledge this idea that Jackie brought up and that was reflected in that fantastic video that we watched at the beginning, is this idea of interconnection between human rights and rights for nature. So I'm obviously going to be talking a lot about rights for rivers, rights for nature more generally, but these concepts are intertwined. And we saw that most particularly and most explicitly perhaps in the judgment of the Constitutional Court of Colombia in their case on the Rio Atrato, the Atrato River. And in that case, the court said that the only way to uphold the specific constitutional rights of the peoples who live along that river, and these are Indigenous communities, they are the descendants of former slaves who have particular constitutionally protected rights in Colombia, the only way for the court to protect their human rights was to recognise the rights of the river. So they saw the river's rights as biocultural, as inherently and intimately connected with the rights of people, and that this was a mechanism for protecting the rights of people as well. So that interconnection has been part of this building momentum and growing conversation around the rights of nature as well. So where do we begin then with this idea of legal personhood? For me, the starting point again picks up on what one of the commentators said during that short video from the Green Rights Coalition, which is that environmental law has been largely insufficient in both protecting the environment and in protecting our own rights as human beings. This is particularly the case when we look at the way that environment law constructs the environment. What is the environment in the eyes of the law? It is an object. It is an object over which humans have dominion. It is there as a resource for human exploitation. Now, we have imposed limits on that, and that's been the history of environmental law for the past 50 or 60 years, has been to try and codify those limits, to try and perhaps increase those limits on human behaviour. But in doing so, we've really firmly entrenched the idea that the environment is nothing but an object. It has no legal rights or powers of its own. It is only visible to the law, only legible, understandable to the law through the lens of human behaviour and human action. This is really intensified when we look at water law. And I frame this around Western water law particularly because Indigenous laws around water are very different. But Western water law constructs water as a mere resource. So rivers are resource providers that we can dominate and exploit. So the question then becomes, can law operate as a mechanism of repair and actually bring us back into good relationships with nature? And we'll move on to the next slide. When we look at this context then in terms of rights of nature, and rights of nature have now been in existence for a very long time, well, a relatively long time, can we see this as part of a process of repair? When we look around the world, local governments in the USA have been recognising the rights of nature since 2006, not perhaps terribly successfully, but this is an ongoing project. And it's a process that really accelerated in a global setting in 2017 when rivers around the world started to receive this status as legal person. And again, we can see this continued acceleration and growth. This is a mere snapshot. If you want to see the 450 odd rights of nature initiatives, go and have a look at the Eco Jurisprudence Monitor website. It'll show rights of nature happening in almost every country around the world, not necessarily always legal, but in the policy or declaration space. I've also bolded the ones here on this slide that show rivers and waterways, because these are natural entities that seem to be inspiring people in very particular ways to create these legally binding rights. Next slide, please, Greta. The next question that we should ask before we even consider whether or not this can be a form of repairing our relationship with the environment is to place it into the context of whether or not this is genuine Indigenous leadership or perhaps another example of colonial environmental values. It is something that settler colonial countries need to be very, very cautious of in our drive and vigour to protect the environment. We can often run roughshod over the rights and interests of Indigenous peoples. So when we're thinking about rights of nature, we need to be aware of the pluralism of experiences and responses from Indigenous communities. So Virginia Marshall writes very strongly against this idea when she says that advocating for legal personality of a river or of nature in general has been done largely on the ground that all humans exploit and abuse the environment. And so she sees this as conflating the behaviours of Indigenous peoples with settler colonial peoples, and that's a trap that we should avoid. She also is wary of the idea of granting nature legal personality, its own legal identity, because of that ongoing process of decoupling, what she calls decoupling the oldest living and continuous Indigenous cultures in Australia from their rights and obligations to and for country. So creating nature as a rights holder, as its own legal identity, can fracture the relationship between people and place. And so again, it's important to be aware of these responses to the rights of nature when we're thinking about the creation of green rights. However, there's a flip side here. Some of the most transformative cases around the world have been consistently influenced and often actually led by Indigenous peoples. So rights of nature is not inherently in opposition to Indigenous leadership or Indigenous laws. It can be if it's not undertaken in the right way, if Indigenous peoples are not involved in crafting and influencing those laws. But one of the ways to avoid this problem is to ensure that instead of just settler colonial laws taking inspiration from Indigenous laws and then integrating that within a settler colonial framework, instead, rather, we should be looking back to Indigenous legal frameworks and saying, is this valid within your framework as well as being valid within the settler state? So this two-way exchange of validity, so that it's instead of imposing or stealing from Indigenous peoples, it's seeking validity and ensuring that the laws that the settler state is creating are actively reflecting Indigenous values and Indigenous laws. It's a challenge. It is not an easily solved one. It is a challenge that does exist everywhere, but it's one that I think we can rise to. Next screen, please. When we think about the creation then of the legal personhood or legal rights holding status of nature in law, there are lots of different ways that this can happen. And when we think about what we're trying to repair, each of these different ways of recognising nature as a rights holder provides a different kind of tool. It repairs a different problem, potentially. So we've got at the top here the legal person. Margaret talked a little bit about that in terms of the idea of a legal person status for corporations. A legal person is somebody who holds rights and powers in law. They have their own legal identity. They have a bundle of rights that are associated with them, including things like the right to sue. So a legal person who represents a natural entity, such as a river, can go to court. They can sue or be sued by people. They can hold property. They can enter into and enforce contracts. These are not necessarily rights that resonate with what we think a river or a mountain or a natural entity might actually want, but they are important in a human context. The subject of rights is akin to a legal person. It occurs in slightly different legal settings, and rather than an assumed bundle of rights, they have the rights that are expressly articulated. So this can be a much more flexible way of recognising nature's rights holding status, and this is what they used in recognising the Rio Retrato as a rights holder. It is a subject of rights, and its rights include the right to preservation and maintenance and conservation. Not notably, as we'll come back to in a second, the right to flow. So again, it depends on whoever is doing that articulation of rights actually understanding what rights a river or a mountain might be interested in having. A living person is a little bit more complicated. The law tends to only recognise human beings as living persons. So if we extend that status to nature, does that start bringing with it human rights and human values and imposing those on nature, or potentially gifting nature with rights that we more usually associate with human beings? This is a tricky space. It can be legally creative, but it's not, again, always what is needed. And then lastly, we have the idea of a living being or a living entity. This is not a rights holder. This will not give the river or the mountain the ability to go to court to protect its own rights. But what it does do is shift the emphasis into relationality. So it says that the most compelling part of this entity is the fact that we now recognise it as alive, as a holistic being, rather than merely an ecosystem or an object that the law sees as having no rights at all. It doesn't rise to the level of a rights holder, but it's more than an object. So it starts to shift us into a space where we need to think about and prioritise what kind of relationship do we want. So when we look at all of these things, the question that we need to ask ourselves then is, what is broken and what are we trying to repair? I'm going to come back to that in a second. I'll just move to the next slide. This slide is a reminder of the importance of asking ourselves both what is broken, what are we trying to repair, but also what rights might a river particularly want. When we look around the world, of all of the many rivers and waterways and lakes that have now legal rights and legal status, only one has any right to the water that flows between its banks. Every single other river, while it might be a legal person and have the right to go to court, does not have any rights to the water itself. The thing that defines a river, its essence, is the presence of water at least some of the time. And yet that is what they are being denied in their current legal construction. So the sole example that breaks this rule is the Rio Akepi in Ecuador. And in that instance, the court said that because all of nature has rights in Ecuador, the river also has rights, and that core to its rights holder status is the idea that it needs sufficient minimum flows to maintain its ecosystem functions. But that has not been replicated anywhere else. The system is slightly better when we look at the processes and institutions of water management. But again, these new river persons tend to play very limited roles in that space too. So we have this significant disconnect emerging between the legal mechanisms we are using to grant rivers rights and water law, which continues to treat them as objects. Next slide, please. So when we look at repairing relations then, and what legal personhood or other rights holder status can do for us in this process, the first question is, what is broken? And this is really important because law as a mechanism of repair, and I'm drawing on the work of Danish Sheikh here, will be focused on what we construe as being broken. So rights of nature in the Western context really emerged from a 1972 paper by Christopher Stone. And in his mind, what was broken was the fact that the court cannot see the injuries to the environment unless they impact human beings. So the crucial problem, the crucial thing that was broken for him and that he thought rights of nature could solve was that it would make nature visible, make the injuries to nature visible, and therefore they could be taken into account. In doing so, rights of nature constructs nature as a competitor. It says nature is now competing in an adversarial system, in a court system, for its rights to be taken into account and be put into the balance along with everybody else's. So it makes another player in the field. It makes another competitor for scarce resources. Is that the problem that is broken? Is that what we're actually trying to fix? Or instead, are we trying to fix our relationship with the environment? If that's what we're trying to fix, then perhaps rights are not the correct tool at all. Perhaps what we actually need is more like a living entity, a body that cannot necessarily go and sue people, that can't necessarily fight its own battles, but one which says you need to ask yourselves what a good relationship is and how you get there. And so this then takes us into my second point on this slide, which is around this notion of whether we need urgent fixes or whether we can be engaged in a longer process of joyful relationship repair. Can we gleefully disrupt, in the words of Zoe Todd, the systems that are binding us into this competitive adversarial arena of a courtroom, and instead seek some other mechanism, some more relational way of being together and centering our obligations that are bound in that mutual interdependence and reciprocity? There are times when urgent fixes are crucial. There are times when we need to go to court, when we need to get the interests of the environment into court very quickly. In those cases, rights of nature, legal personhood may be the most effective strategy, but we need to be very careful and strategic about the choices that we're making. And I think what we, as a long game, need to be focused on is this idea of joyful repair. It takes longer, it's slower, but it may be ultimately more sustainable. And of course, finally, we need to think about how we're bridging this gap between the legal mechanisms that continue to perpetuate the idea that the environment is nothing more than an object. Water law is not alone in that instance. It is a clear example of an egregious problem, but it is certainly not the only sphere of law that continues to perpetuate it. And final slide, please, Greta. So the takeaway messages for me in this conversation about green rights. I think we can use the law to repair our relationship with rivers and with other parts of the environment, but we have to begin by centering relationships with Indigenous peoples and local communities and recognising that these are separate entities and that different processes will be needed in both instances. They need to be driving law reform, partly because in each case and for different reasons, they will know the environment best. They will know the water best, the river best, the mountain best, and they need to be driving these reforms. We cannot fall into the trap of green colonialism. We can repair our relationship with rivers if we integrate changes to the legal status of rivers with water law. We need to bridge that gap and make sure that these multiple spheres of law, some of which continue to operate in a resource extraction mindset, are talking to each other and that we're replicating these reforms across all of those fields. We also shouldn't be afraid of mere symbolism. So recognising a river as a living entity is not a legally powerful step to take. It may not get you into court. It may not be the urgent fix that you need, but it lays the foundation for a completely different kind of conversation about the world we want to create and how we want to create it together. The Birrarung that flows through the heart of Naarm in Melbourne is a living entity in law. And what we're seeing is a shift in narrative. Instead of a focus on what we can take from the river, we are now talking about what we want for the river and how we get there with the river itself becoming a partner and a collaborator in creating this better future. And that's the opportunity of what looks like mere symbolism, is that it creates that very different hope, that very different vision of a future that we can create together. And that's where I'll wrap up. Thanks, Margaret.
Thank you very much, Erin. Thank you for such profound questions raised, not only about our relationship in an era after colonialism, but also asking us to reflect on what law is. Is law creating an adversarial system, or could it be that we haven't had a chance to test Christopher Stone's ideas about whether trees should have standing because they were never adopted? They have influenced philosophy and law, but haven't actually influenced to a very great degree the practice as it stands today. And I guess green rights is an opportunity in some of its form to test whether Christopher Stone might be right. I particularly like his ideas about guardians in the oceans. So he's often talked about in relation to trees, but the marine space is also, I think, a great focus of his. But I also embrace this invitation to reflect broadly on what law is to us and what we hope to perpetuate in terms of our relationships. So with that, let me introduce our third speaker, Mr. Dylan Asafo, who will address green rights in the Pacific Islands. Dylan is Senior Lecturer at the University of Auckland and a current PhD candidate at Melbourne Law School. His Masters of Laws from Harvard University included work on human rights and climate justice in the Pacific, and the title of his PhD thesis is To Protect Oceania Towards an Understanding of Pacific Peoples' Engagement with International Law. He is acting for the Cook Islands in its engagement with the current advisory opinion proceedings of the International Court of Justice on climate obligations. Over to you, Dylan.
Hi there. Talo falava ma lole soifu moa malalangi mama. It's such a great privilege to be able to be a part of this webinar. Thanks so much, Margaret, for organizing it. And thanks also to the Green Rights Coalition for an exciting set of webinars around the world. So my contribution is going to focus on green rights in the Pacific Islands, as Margaret mentioned. Specifically, I'll talk about some key developments around green rights in the Pacific Island states of Fiji and Papua New Guinea, or PNG, and some of the interesting questions and issues that these developments have raised for those of us working in the region, specifically in areas of environmental protection and climate justice. So I'll start with Fiji. So in 2013, Fiji became the first Pacific Island state to enshrine green rights in its constitution, with Section 40, Clause 1, stating that every person has the right to a clean and healthy environment, which includes the right to have the natural world protected for the benefit of present and future generations through legislative and other measures. But while this provision is a significant step forward for green rights, the very next clause, in Section 40, Clause 2, provides for limitations on this green right and states that to the extent that it is necessary, a law or an administrative action taken under a law may limit or may authorize the limitation of the rights set out in this section. It might be interesting to note that unlike the other limitations provisions for other constitutional rights in the Fiji Constitution, like the right to freedom of assembly and the right to fair employment conditions, this limitation provision doesn't specify or list out the various grounds for limiting this green right, like, for example, national security, public safety, or public order. There's just this very broad discretion and authorization for the state to place limitations on green rights as it sees fit. So that said, how has this green rights constitutional provision in Fiji's constitution operated to protect the right to a clean and healthy environment in practice? In my opinion, it's yet to prove to be an effective source of protection for the environment and the people of Fiji. And this unrealized potential, in my opinion, was illustrated last year when the Fijian government endorsed the Japanese government's plans to dump 1.3 million tons of nuclear waste into the Pacific Ocean from August 2023 onwards. Importantly, the Fijian government's endorsement of Japan's plans went against the views of an independent panel of experts who stated that there's insufficient data to deem the discharge of nuclear waste safe for release into the Pacific Ocean. And unsurprisingly, the government's support for the dumping plan was met with a significant amount of outrage by the Fijian public, NGOs, and also civil society organizations in Fiji. For example, in a statement, Fiji's Human Rights and Anti-Discrimination Commission noted that Japan's plans and Fiji's endorsement of the plan violated Fijians' rights to a clean and healthy environment as protected by the Constitution, and implored the government to reject the plan to uphold its constitutional obligations. This statement also noted the General Assembly's resolution from 2022 that Jackie mentioned, and said that it's a universal human right, and emphasizes that it's the duty of everyone to protect that right. And importantly, their statement also noted that the green right to a clean and healthy environment is interlinked and interdependent with other fundamental human rights in Fiji's constitution, like the right to life, health, food, and water, among others. Other really important points were made by Fiji's NGO Coalition on Human Rights, who stated that the government's endorsement of Japan's plans violated the regional treaty of Rarotonga, which Fiji and other Pacific states, as well as Australia and New Zealand, are party to. And this treaty states that parties are to prevent nuclear dumping in the Pacific region. The coalition also stated that Japan's dumping plan also contradicts Japan's own obligations under the United Nations Convention for the Law of the Sea to protect and preserve the marine environment, especially in regard to marine pollution. And the coalition also stated that Fiji must make a stand and demand for redress by the International Tribunal for the Law of the Sea, or IILAH. And sadly, despite this outrage and advocacy, as of today, the Fijian government has shown no desire to pursue anything against the Japanese government at the IILAH. And I'm also unaware of any plans or moves by Fijians to take legal action against the Fijian government under the constitutional protection of green rights in Section 40. So I guess given the strong case that Fiji and Japan are violating constitutional human rights and also other instruments like the Treaty of Rarotonga and the UNCLOS, the question that arises is, why is the Fijian government endorsing this plan? What does it have to gain when there's such great outrage by Fijian citizens and NGOs? Well, according to some Fijians, Fiji's support can be explained by the great debt that Fiji owes to Japan. And this broader problem in the Pacific has been called debt trap diplomacy. This idea that because the Pacific islands, broadly speaking, are disadvantaged and have to rely on aid with aid from other states, that they are trapped into disadvantageous or harmful agreements for its citizens. And so the executive director of the Fiji Council of Social Services remarked, for example, look at our debt composition and then you can figure out something. We owe money to the Japan International Cooperation Agency. We owe money to the European Investment Bank. You do the math. They also suggested that Fiji's support for the plan can be explained by colonial and racist paradigms of the Pacific, in particular, the paradigm that the global North has about the Pacific Ocean and its peoples, that it can be used as a dumping ground. And she suggests that it will be good to have leaders in the Pacific who understand that we are fighting a paradigm that sees the Pacific and Pacific Islanders as much less deserving of dignity. We are not a dumping ground, and that has to be communicated from the highest office. So in my opinion, the nuclear dumping controversy shows the limitations of green rights in practice in the Pacific, even when they are constitutionalized in the supreme law of the land. And I don't just mean the technical legal limitations that can be placed due to limitations provisions, but also the limitations imposed by ongoing realities of neocolonial development, global North imperialism, which all make it hard for these green rights to be protected in practice. One slightly more encouraging development regarding green rights in the Pacific comes from the state of Papua New Guinea, or PNG. Interestingly, there are no explicit green rights in the PNG constitution, like the right to a clean and healthy environment. But in 2020, the PNG National Court of Justice recognized the right and affirmed that it very much exists and can be enforced by the court against the state government, companies, and individuals. In this case, the PNG government enlisted the China Harbour Engineering Company to reconstruct a bridge in 2015, and its project was completed in 2018. And several of the families who were living nearby the construction site went to the court saying that they had suffered severe damage because of the construction, and also claimed that the company had bypassed requirements for an environmental impact assessment for permits, and therefore that they were trespassing and also liable for unlawful land conversion, and that they had violated their right to life under PNG Constitution, which also requires individuals and companies to protect the right to a clean and healthy environment, as recognized internationally and in other jurisdictions. The company tried to have the case thrown out with an application to dismiss the proceedings on 2 grounds. Firstly, that the plaintiffs lacked sufficient standing, and secondly, that the causes of actions were not reasonable and sufficiently articulated. However, the court dismissed the company's application to dismiss, first on that standing point, saying that the PNG Constitution allows interested parties to have standing in court when their fundamental rights are directly infringed, even if they are not directly affected. And the company tried to argue that because a lot of the plaintiffs, so there were 80 plaintiffs in total who were locals in the construction area, they were tenants, so they weren't actual landowners. So the company tried to say that that meant that they didn't have standing. Only the people who owned the land or had title to the land could bring a claim. But they said no, in reality, their fundamental rights are engaged and infringed, and therefore, under Section 57 of the PNG Constitution, they have standing. And in regards to the particular fundamental rights that were engaged and infringed, the court said that's not just the right to life, but the right to a clean and healthy environment, which exists in PNG law through the right to life. And specifically, the court said life means something more than mere animal existence. It embraces both physical existence and a decent quality of life, a guarantee supported by a healthy environment. The court supported its affirmation of the green right to a clean and healthy environment by citing with approval the 1972 Stockholm Declaration, statements from the UN Special Rapporteur on Human Rights and the Environment in 2018, the agenda case, and also the court, interestingly, relied heavily on Indian constitution law jurisprudence, specifically cases affirming the right to life includes and requires the protection of the right to a clean and healthy environment. So just to emphasize, because the court recognized green rights in PNG law, it decided not to throw out the case against the company as the company was applying for, and allowed these families to provide a more detailed state of claim at a later date. In these later proceedings, green rights or human rights arguments were actually advanced. I'm not too sure why that was, but the lawyers instead went for arguments for damages and compensation based on trespass, negligence, loss of income, and unlawful conversion. But in February last year, the court found in favor of the families that had been affected and said that they had been harmed by the company's project and they were owed damages to the tune of 7.7 million PNG kina, or roughly 3.16 million Australian dollars. And I also saw a story from August last year that the company is now trying to get out of paying this amount by suggesting negotiations, but the families are refusing to, saying that the order is binding and that they will sue them again if they continue to refuse. So this PNG case study shows that there's hope for green rights claims in the Pacific, at least in this limited way where they can be invoked to help prevent claims of environmental harm from being thrown out. I'll leave it there for time, but I'm happy to answer more questions in the Q&A. Thanks so much for listening.
Thank you so much, Dylan. Thank you for giving us a snapshot of some issues facing countries domestically in the Pacific, but also highlighting how those really depend upon relations with other states. So the international law dimension is clearly relevant to the environmental issues that you raise, and that I think gives us a pause for thought on how international environmental law and green rights can be productive. Now we have a couple of questions in, well, more than a few in the chat, and they relate to a number of questions for our speakers. But because we're out of time, I'm going to invite those people who've posed questions to get in touch with the speakers if you like. So you can email any of us at our Melbourne Law School addresses and continue the discussion with us, and of course, to participate in the Green Rights Coalition forums as they continue to develop today on Earth Day and beyond. I wish now then to conclude the webinar with thanks to those who presented today, Jackie Pill, Erin O'Donnell, Dylan Asafo, and you've all given us a deeper understanding of the political and legal context of green rights. Thank you also to those who've helped organise the virtual and the in-person engagement, including within the Institute of International Law and the Humanities, Melbourne Climate Futures, and the Melbourne Centre for Law and the Environment. Thanks especially to Greta Robenstone, our digital content producer, and to Alex Dela Cruz, who's been conducting the in-person session here on level 9 at the law school. Finally, I need to thank our colleagues at the Green Rights Coalition, especially Jan Aguilar and Morgane Garon. Working around the world on Earth Day, as we are doing today, depends on the ingenuity and energy of many individuals, as does the concept of green rights itself. And I think it is this kind of commitment that can make a difference in reforming and improving the law to help the Earth. Thank you.